Good afternoon, everyone. Today I'll be presenting my seminar on right to information and medical sciences. The things which we are going to cover are the basic concepts of the history behind the Right to Information Act within the context of medical sciences, its legal frameworks regarding RTI in healthcare, and the need to discuss the necessity of medical records and issue of medical negligence, and a generalized summary as well. RTI Act and the medical profession. Right to Information Act was enacted in the year 2005 as a progressive enabling legislation with the object of assigning meaningful role and providing the access to the citizens. It ensures openness, transparency, consistent with the concept of participatory democracy and a constitutional right to seek information and be informed. It also ensures that the government and their instrumentalities are accountable to the governed and checks corruption, harassment, and the red tapeism, that is the cumbersome bureaucratic observed by the Justice Sanjeev Khanna of Delhi High Court. So, Central Information Commission has examined the issue of right of patient to have medical records in Nisha Priya Bhatia versus Institute of Human Behavior and Allied Sciences file and stated that the patient has the right to his or her medical record and respondent hospital authorities have a duty to provide the same under the Right to Information Act of 2005 and Consumer Protection Act of 1986. The medical council as per the world medical ethics. Basically this case was this girl Nisha Priya, she filed a case regarding in the hospital regarding her father who was an epileptic patient. After her death she asked for the medical details uh, for which she was denied, and then she filed a petition regarding the same. The Commission recommended the public authority to develop a time frame mechanism of disclosure of medical records to the patients or their relatives with safeguards for privacy and confidentiality of the patient. The MCI has imposed an obligation on hospitals as per the regulations notified on the 11th March 2002, amended up to December 2010, to maintain the medical record and provide its access to the patient. With the enforcement of MCA regulations 2002, it is made clear that the patient has the right to claim medical records pertaining to his treatment, and the hospital are obliged to maintain them and provide them to the patient on request. So the obligations for the hospital regarding the medical records. Firstly, the maintenance of medical records. Hospitals are required to maintain these records for all patients for at least a period of 3 years from the date of commencement of treatment in a standard performa laid down by the MCI, notified by the MCI. This is a generalized thing. It varies from state to state. In some states, the institutions are required to keep the records for about 5 years, but at least it's for a 3 year period time. That even after a period of 1 year, if a patient's attendants come for the documentation, the medical institute is obliged to give it for at least 3 years. Patients have the right to access their medical records. Hospital must provide copies of these records upon request, ensuring that the patient can obtain the information regarding the same. Registration requirement. All clinical establishments must be registered with the state government, and they are obliged to comply with the regulations regarding the provision of medical records. Timely provision as well. The medical record should be provided to patients at the time of discharge or at the time of or at the end of the treatment. If not available at that time, they must be supplied within 3 days of the request. Transparency and accountability. The MCA regulations emphasize the need for transparency in the treatment process, ensuring that the patients or the relatives can verify the quality of care provided. Consequences for non-compliance. If a hospital fails to provide medical records as required, it may face penalties, including deregistration and other disciplinary actions after an appropriate inquiry. But this hasn't come to a conclusion to the fact that it hasn't been properly described what would be the penalties. It's basically varies from case to case. The legal framework regarding RTI in healthcare. The RTA Act and the Consumer Protection Act collectively reinforce the rights of the patients to obtain the medical information. The MCI mandates that the patient should receive the copies for their medical records at the discharge. Failure similarly can lead to penalties, including deregistrations of the clinical establishment after an inquiry. Necessity of the medical records and the issue of medical negligence. With the growing population and the increasing negligence and misconduct committed in the medical profession, the citizens suffer, and in the absence of any remedial measure to check the menace, irreparable loss and injury may be caused to the patients and their attendants. Otherwise, also there are number of statutes where confer statutory right to citizens to claim damages, compensation, and punish the guilty medical professionals. To avail the benefit of the statutory provisions and prosecute the medical profession in the event of negligence, it is necessary to provide medical record to patients or their attendants as the case may do. So this is specific to the for the state government of UP in compliance to the High Court order regarding the same. As all the clinical establishments as defined by the Clinical Establishment Act 2010, including nursing homes, medical professionals, private and government sponsored hospitals of the names, whoever may be, medical colleges shall provide the copy of medical records to the patients or their attendants as the case may be at the time of discharge. The medical professionals as well as competent authority of the clinical establishment shall maintain the standard of their clinical establishment with hygienic condition in accordance with the standard prescribed by the MCI or other medical councils or authority. This is valid for all allopathic, Ayurvedic, homeopathic or Unani treatments as well. Clinical establishment under names and designations, whoever it may be. The prescription memo of the medical professionals or the admission form, as the case may be, shall contain a caption that you are entitled for the copy of medical records at the time of discharge. No clinical establishment shall work unless they are registered with the state government by an authority provided for the purpose or chief medical officer of the district concerned as the case may be. In any case, for any compelling reasons, the medical records are not provided at the time of discharge. It shall be provided within 72 hours, as by the regulations framed by the MCI. The option may be given for online registration as well, and the name of all clinical establishments and medical professionals of whatsoever branch may be shall be placed on the website, so that people may have the access for it. The registration should be done at reasonable fees. Let the registration of the all clinical establishments be completed expeditiously within 4 months from the date of insurance of government orders. In case of any complaint following an inquiry, it is found that the medical record has not been provided at the time of discharge or within the 72 hours, then after appropriate inquiry and show cause, the government may deregister and such clinical establishments to pursue further with activities of medical care and treatment, and may also impose penalties. So, uh, the summary for it, the RTA Act allows people to request the information from public authorities, including hospitals, with aims to make government action more transparent and reduce corruption, which includes, in context of the medical sciences, the patient's rights to seek for medical records, and also in court cases as well. The documents mention several legal cases where patients fought for the right to access medical records. Responsibilities of the doctors and hospitals is also kept in check. The medical professionals must keep accurate records and give them to the patients when asked. And also the privacy versus the access need to be taken care of as well. While the patients have the right to their information, hospital must also protect patient privacy as well. For this there is a need to find the balance between sharing records and keeping personal information confidential as well. Legal support as well. The document highlights various laws that supports patient rights to information and ethical duties of the healthcare providers. This is my reference, and thank you.